Millions of people thought they were watching another Donald Trump spectacle, another loud courtroom confrontation that would explode across cable news for 12 hours, flood social media with reaction clips, then dissolve into the endless background noise of American politics. Another performance, another headline, another moment where Trump walks into a room, dominates the atmosphere, attacks the people accusing him, and walks back out telling supporters he won. But what actually happened inside that Manhattan courtroom was much more dangerous for Donald Trump than a bad news cycle. Because for a few uninterrupted minutes, the mythology stopped working. The cameras outside the courthouse captured the familiar image first. Donald Trump glaring toward reporters, making the "my lips are sealed" gesture, like a man mocking the entire process before he even entered the building. The same body language Americans have seen for years, defiant, smirking, performing control before the first question is even asked, the political version of a driver revving the engine before a street race. Then he walked into Judge Arthur Engoron's courtroom and ran directly into the one thing Donald Trump has spent most of his public life trying to overpower, a system that does not care about his branding. That is the real story here. Not just the New York civil fraud case. Not just allegations that Donald Trump inflated the value of his assets by billions of dollars to banks and insurers. Not even the possibility of massive financial penalties against a former president. What unfolded in that courtroom was something larger and far more revealing. It was the collision between political performance and procedural authority, between a man who built a movement around dominating the room, and a judge whose entire institutional role is to make sure no individual dominates the room. And the tension started before Donald Trump even opened his mouth. Trump wanted to personally deliver his own closing argument. That alone was unusual. Civil defendants do not typically stand up and freestyle their own closing statements in fraud trials. Lawyers do that. Courtrooms are structured environments. Every second is regulated. Every argument is supposed to stay inside the boundaries of evidence already presented to the court. Judge Arthur Engoron did not reject Trump's request outright. In fact, the judge offered something incredibly simple. Trump could speak if his legal team guaranteed he would stay focused on the law and the facts already entered into evidence. No campaign speech, no political rant, no improvisational detours about persecution or witch hunts, a basic condition. The kind of condition that ordinary defendants comply with every single day in courtrooms across America without national controversy. But here is where the situation began to crack open. Trump's own attorneys would not make that promise. Think carefully about how extraordinary that is. Lawyers representing a former president of the United States could not assure a judge that their client would follow standard courtroom procedure during a closing statement. They knew exactly what he was going to do. They knew the courtroom was about to become something else entirely. And moments later, that prediction exploded in public. When Judge Engoron directly asked Donald Trump whether he would stay within the legal guidelines, Trump did not simply answer yes or no. He immediately launched into grievances, political persecution, witch hunts, claims that the case itself was a fraud on me. Then came the line that changed the atmosphere inside the courtroom completely. "I know this is boring to you." Not directed at a television audience, not posted online. Directed straight at the judge presiding over the case. And in that instant, the fraud trial stopped looking like a normal legal proceeding and started looking like a stress test for the authority of the American courtroom itself. Because the moment Donald Trump said, "I know this is boring to you," he stopped acting like a defendant trying to persuade a judge and started acting like a customer furious that customer service would not break the rules for him. That is the deeper psychological layer underneath this entire confrontation. Trump entered that courtroom believing the environment would eventually bend around his personality the same way television interviews, campaign rallies, and Republican primary debates often have for years. Judge Arthur Engoron answered that assumption with 4 words that sounded procedural on the surface but carried the force of a public institutional rebuke. Control your client. That sentence landed like a hammer inside the room because everybody immediately understood what it meant. The judge was no longer speaking to Donald Trump as a former president, a political candidate, or a media phenomenon. He was speaking to him as a courtroom management problem, a defendant whose behavior had crossed the line from advocacy into disruption. And notice something critically important here. Judge Engoron did not explode emotionally. He did not insult Trump. He did not launch into a political speech about democracy or constitutional norms. He responded like judges are trained to respond inside structured proceedings. First the warning, then the directive, then the time limit. 1 minute. Donald Trump had 1 minute remaining before the court recessed for lunch. That detail matters because time limits in courtrooms are not symbolic. They are authority made visible. A judge deciding who speaks for how long and under what conditions is the entire architecture of courtroom power condensed into a single procedural act. It is the opposite of a campaign rally where the loudest voice controls the emotional temperature of the room. And Trump hated it. You could see it in the rhythm of his responses. Instead of narrowing his argument, he widened it. Instead of focusing on evidence entered into the record, he drifted further into grievance politics. The allegations of inflated asset values, the financial statements, the representations to banks and insurers, those issues became secondary. Trump kept trying to put the trial itself on trial. That is one of the oldest rhetorical escape routes in political crisis management. If the facts are dangerous, attack the legitimacy of the process examining the facts. And to understand why that matters, you have to look at the actual allegations surrounding this case. New York Attorney General Letitia James accused Donald Trump and the Trump Organization of systematically inflating property valuations for financial advantage. Court documents described years of allegedly exaggerated net worth statements used in dealings with lenders and insurers. The numbers involved were not minor accounting disputes. We are talking about claims tied to billions of dollars in valuation differences. Those are the receipts. Those are the actual stakes inside the courtroom. But listen carefully to what Donald Trump did not spend much time addressing during the confrontation itself. He did not calmly dismantle the accounting analysis point by point. He did not walk the court through a technical rebuttal of the asset calculations. He did not surgically challenge the methodology behind the valuations. Instead, the emotional center of his argument remained persecution. That distinction is enormous. Because once a defendant shifts the focus from the evidence is wrong to the system itself is corrupt, the courtroom stops functioning as a fact-finding venue and starts becoming a battlefield over institutional trust itself. And this is where the moral contrast becomes impossible to ignore. An ordinary defendant in an ordinary fraud case does not get to turn procedural warnings into national political theater. An ordinary businessman accused of misleading banks does not leave court, skip the afternoon session, walk into a nearby building he owns, stand in front of cameras, and immediately relaunch the confrontation as a media event designed to energize supporters. But Donald Trump did exactly that. The moment the courtroom imposed limits, he moved to a venue where no judge could cut off his microphone. That pattern is not accidental. It is the strategy. And the strategy only works if the public gradually forgets the difference between a courtroom and a campaign stage. That distinction is everything here. Because courtrooms are intentionally designed to suppress charisma, that is why witnesses answer specific questions instead of delivering monologues. That is why evidence has rules. That is why judges impose time limits. The system is built around the idea that emotional dominance should not outweigh documented facts. In theory, the loudest person in the room is supposed to have no special advantage once proceedings begin. Donald Trump has spent nearly a decade proving he can overpower almost every modern American institution through sheer force of narrative. Cable news adapted to him, Republican leadership adapted to him, opponents adapted to him, even scandals adapted to him. Stories that would politically bury most public figures became temporary turbulence inside the Trump media ecosystem. But courtrooms are slower than social media, less emotional than rallies, less flexible than politics. And that is precisely why these confrontations keep escalating. Look at the sequence carefully. Trump wanted permission to speak freely. Judge Engoron asked for a guarantee that Trump would follow procedural boundaries. Trump's lawyers would not provide that guarantee. Trump then ignored the spirit of the restrictions anyway, launched into political grievances, insulted the judge indirectly to his face, forced the judge to intervene publicly, then left court entirely and continued attacking the proceeding outside the building. That sequence matters because it reveals a deeper operating assumption underneath Trump's public behavior. Rules are legitimate only when they do not interfere with his objectives. And before supporters dismiss that as partisan interpretation, look at the pattern beyond this specific courtroom. Trump has repeatedly attacked judges overseeing cases involving him. He has called judges biased, corrupt, deranged, disgraceful. He attacked Judge Arthur Engoron. He attacked judges in criminal proceedings. He even attacked judges he personally appointed once they ruled against him. When courts upheld decisions Trump disliked, the response was often not, "the court interpreted the law incorrectly." the response became personal delegitimization. That is not normal presidential behavior. And it becomes even more dangerous when millions of people begin absorbing the message that judicial authority itself is suspicious whenever it produces outcomes unfavorable to one political figure. Because eventually the target stops being one judge. The target becomes the idea of neutral arbitration itself. That is the real institutional danger hidden underneath all the viral courtroom clips and dramatic headlines. Not whether Trump insulted a judge. Not whether the judge looked frustrated. Not whether cable news panels argued over courtroom etiquette for 24 hours. The danger is that America slowly becomes conditioned to see every legal restraint as political oppression and every procedural boundary as evidence of conspiracy. That mentality destroys republics from the inside because it turns accountability into persecution, depending entirely on who the defendant is. And here is the moral contrast nobody should ignore. Imagine an ordinary American defendant in a financial fraud case behaving this way in court. Imagine a local businessman accused of falsifying valuations, interrupting proceedings, insulting the judge, refusing to stay inside procedural boundaries, then storming out to hold a press conference attacking the legal system while the trial is still underway. Would that defendant be treated as a folk hero? Would millions celebrate the behavior as strength? Or would people immediately recognize it as contempt for the institution overseeing the case? That question cuts to the center of the entire confrontation because the courtroom itself was trying to answer it in real time. Judge Arthur Engoron was not demanding ideological agreement. He was demanding procedural compliance. Stay within the rules, answer within the framework, respect the structure of the proceeding. The same expectations imposed on every defendant who enters an American courtroom. And Donald Trump's reaction exposed something deeply revealing about modern political culture. Millions of Americans no longer judge public figures by whether they follow rules. They judge them by whether they dominate the spectacle surrounding the rules. That is why this confrontation felt so unsettling. Because for a few visible minutes, the spectacle lost control of the room. And the institution pushed back. And maybe that is why this moment hit so differently from all the other Trump courtroom headlines Americans have grown numb to over the years. Because this was not a dramatic FBI raid photo, not a leaked tape, not a campaign speech outside a courthouse designed for television clips. This was something quieter and in many ways more threatening to the mythology itself. A judge simply saying no. No, you cannot turn closing arguments into a political rally. No, you cannot ignore procedural boundaries because cameras are watching. No, you do not get unlimited control over the room just because you once occupied the Oval Office. That sounds basic. Almost boring, until you realize how much of modern political culture now depends on convincing the public that limits themselves are illegitimate whenever they apply to powerful people. And this is where the entire confrontation stops being about Donald Trump personally and starts becoming a mirror reflecting something deeply unstable inside American civic culture. Because institutions do not collapse all at once, they erode gradually when enough people stop believing rules deserve obedience in the first place. Not because every judge is perfect. Judges are human. Courts make mistakes. Prosecutors overreach. Political bias can exist inside any institution populated by human beings. Serious democracies are supposed to debate those realities openly. But there is a massive difference between criticizing a judicial ruling and treating the entire legal framework as inherently fraudulent any time it restrains one specific political figure. That difference matters. Without it, every courtroom becomes just another campaign battlefield. Every indictment becomes election interference. Every procedural limit becomes censorship. Every unfavorable ruling becomes proof the system itself is fake. And eventually, the public stops asking the most important question in any legal proceeding. What do the facts show? Instead, they ask only one thing. Which side am I supposed to cheer for? That is poison for a legal system. Because law is supposed to function precisely when emotions are hottest, precisely when tribal loyalty pressures people to excuse behavior they would condemn in someone else. The entire point of procedural rules is to prevent raw power, celebrity, wealth, and political influence from overwhelming factual accountability. That is why the control your client moment mattered so much. It was not dramatic because the judge raised his voice. It was dramatic because, for one brief moment, the institutional structure held firm against a personality built around refusing restraint. And the visual contrast could not have been clearer. Inside the courtroom, a judge imposing time limits, procedural standards, and evidentiary boundaries. Outside the courtroom, Donald Trump immediately returning to microphones, cameras, applause lines, and political framing, two Americas operating simultaneously. One built around institutional process, the other built around emotional allegiance. And millions of Americans are now being forced to decide which version feels more legitimate to them. That is the real trial hidden underneath the fraud allegations. Not simply whether Trump inflated asset valuations. Not simply whether banks received misleading financial statements. Not simply whether Judge Arthur Engoron handled the courtroom correctly. The deeper question is whether Americans still believe powerful figures should be constrained by the same procedural rules as ordinary citizens once they step into court. Because if the answer becomes no, then the courtroom itself changes. It stops being a place where evidence outweighs influence. It becomes another arena where power determines reality. And history shows what happens to countries that drift too far into that mindset. Trust collapses, neutral institutions weaken, public cynicism hardens into permanent suspicion. Every legal outcome becomes illegitimate to half the country before proceedings even begin. That is why this confrontation mattered far beyond Manhattan. The fraud trial exposed a pressure point inside the American system itself, a collision between institutional authority and personality-driven politics that is only becoming more intense with every new indictment, every new hearing, every new courtroom clash involving Donald Trump. And the next collision is coming. Maybe in another courtroom, maybe in another state, maybe in another case entirely. But the underlying question will remain exactly the same. Can the American legal system still enforce limits against people powerful enough to convince millions those limits should not exist? If you think this conversation matters, hit like, drop your thoughts in the comments, share this video with someone following these cases closely, and subscribe for more deep breakdowns of the stories reshaping American politics and institutional trust.